Now, tonight is the end of week 9 for the 10 weeks of the course. This is class 18 out of 20. This is part 3 of the Iran-Contra case. That you remember that we divided it into the part 1 was the actual preliminary investigation that preceded the filing of the case. The part 2 was the discovery process, the defendants fighting us off and Judge King not ordering them to comply, and us fighting our way all the way to it, to the point where we ended up at the end of Tuesday with Judge King. There were a series of events that took place. That the October 5th of 1986, remember we'd filed in May of 1986. In October of 1986, the Hassenfuss C-123 had gotten shot down. We'd gotten him to come forward and give all the details of what the information was, so that it supplied a ton of information in an authoritative way that might otherwise have been hoped to have been gotten through the discovery process. But even though it's a kind of a peculiar discovery event, we got it. And then there was the testimony that we did on October 15th in front of the House Foreign Affairs Committee, and in Judge King's order of contempt, to have me held in contempt of court for publicly revealing to the Congress the existence of this lawsuit and what the substance of the charges were, and my having met with Ross Perot and briefed him and gotten the wire diagram and the memo put together to give to Bill Webster, the head of the FBI. And that's when that investigation began, is when we began to get the shredding of documents by Oliver North and his secretary Fawn Hall, which actually directly involved Tom Green, their lawyer, actually participating with them in that. And then on November 24th of 1986, the emergency press conference that was called by Ed Meese, the Attorney General for the Reagan-Bush administration, announcing that he felt that it was required to appoint a special prosecutor because he found that there was this young renegade lieutenant colonel in the National Security Council who seems to have run amok and gone around recruiting a lot of former military and CIA people to engage in an operation that appears not to have been authorized by anyone. So what I did at that point is, when they called for the appointment of the special prosecutor was appointed on December 19th of 1986. I filed immediately a full-scale affidavit with Judge James Lawrence King, laying out all the details of the information that we had in an attempt to stave off their effort, to stave off their effort to get rid of this case, because the case itself is what was driving everything. The Congress of the United States hadn't done anything to investigate. As I told you, the U.S. Attorney's Office with Leon Kellner down in Florida had refused to do anything. We'd gone to Tip O'Neill in the House of Representatives, and they said, well, we have to wait until after the Democrats win. And they hadn't appointed any congressional committee or anything. So what we did is we filed the full-scale bomber affidavit with the court, declaring to them what it is that we had found out and what they were doing. And we expected to be able to have that stave them off. And that, but James Lawrence King, who was the judge, as I pointed out to you, we discovered later was a member of the board of directors of Meyer Lansky's National Bank of Miami. Had been appointed by Richard Nixon at the request of B.B. Rebozo, a major mafia connection. And you can actually find some information about him in the New York Times, December 1st, turns out of 1969. There's an article that we hadn't found that actually acknowledged that he was on the board of directors of Meyer Lansky's bank. So we filed our appeal immediately from his Rule 56 order of summary judgment. He retaliated by saying that if we appealed, he was going to accept a motion from the defendants to make us pay for all of their attorney's fees and costs. So he was trying to get the case dismissed, have it go away. If we had stopped right at that stage, then there would have been no resolution of the issue in a court, but at least we would have survived. But he threatened us with a Rule 11 if we filed the appeal from his complaint, or from his order of summary judgment. And so we filed our appeal. He required us to file a $1.2 million cash bond. Wasn't going to allow a bond with a 10% bond. He even says that cash had to be provided, and we did that. And then we stood by waiting to get the appeal processed. So while that was going on, the proceedings then began. Walsh, as I say, that Walsh had indicted 6 people already. That's what actually triggered Judge King dismissing the case, because the first 6 people that were indicted by the special prosecutor appeared in front of Judge Gazelle in Washington, as I mentioned, asked to have all the criminal procedures postponed until they dealt with the civil case. And Judge Gazelle obviously called Judge King and asked him to postpone events in our case. And Judge King, rather than do that, just accelerated the whole thing, said we were going to trial immediately, and in fact entered an order of summary judgment on the Thursday evening before the Monday trial. So we were scheduled to go up in front of the Court of Appeals in a way that would have been actually going on at the same time that the special prosecutor was continuing to prosecute members of the off-the-shelf enterprise and the White House National Security Council people that were involved with them. And so we went up to the 11th Circuit Court of Appeals, but a peculiar thing happened. The 3-judge panel that was assigned to hear our case, the chief judge on the 3-judge panel, Judge Robert Vance, was killed with a letter bomb. Was sent to his home, and he was killed. And they stopped our proceeding and had to await for the appointment of another judge. And H.W. Bush appointed Stanley Birch Jr. to take the place of Judge Vance. And I mentioned Stanley Birch Jr. had never been a judge a day in his life. He was, in fact, the patent lawyer for the Cabbage Patch Dolls, and a major financial contributor to Bush's campaign. And so he was appointed to sit on the panel that was going to hear our appeal. And so while we were in the process of preparing our appeal, then the other proceedings commenced. And the first thing that happened was that Ronald Reagan appointed a Tower Commission. He appointed Senator John Tower to be the head of a commission to investigate these allegations about Oliver North. And very quickly, the Tower Commission did its job, performed the service for which it had been put in place, and it came back trying very hard to divert all of the blame to Oliver North, saying, in fact, in its findings, saying that that they were unable to find any kind of evidence indicating that anybody other than Oliver North was involved in these matters. They said that, in fact, he had prepared a memo for Poindexter and for Reagan's signature, but there was never any evidence that it had ever been signed by either one of them, or even seen by either one of them. No evidence has emerged to suggest that this memorandum was ever placed before or signed by either Poindexter or the president or any other high-level government official. And then they went on to suggest that the real problem, the only problem they'd been able to uncover in their investigation, was that the president's style, management style, had presented a problem because it placed an awful lot of responsibility on his subordinates. That's putting it lightly for Reagan. It basically had everybody doing everything except Reagan. And basically these guys all were operating under the control of George Bush, his vice president. That Bush chaired the 5412 Committee, the National Security Council. This whole thing was run out of the National Security Council. And Oliver North was the deputy director of the National Security Council in charge of anti-terrorism. That was his post. And that was a harbinger of things to come. The utilization of this theory of terrorism as a rationale for basically suspending all of the normal constitutional procedures that were required. So that, and these people, these people in the Tower Commission, it was actually quite humorous. They say things that the president appears to have proceeded with a concept regarding the initiative to sell the weapons to the Hezbollah that does not accurately reflect the reality of the operation. It's kind of an interesting way of putting it. The president was proceeding with a concept that didn't accurately reflect reality. It's kind of an interesting way of putting it. This is because he kept saying that we were not giving any support to the Contras. We are under no circumstances providing any weapons to the Hezbollah, and we are under no circumstances exchanging weapons for hostages. That was the concept that he was functioning under. The reality was, of course, completely 180 degrees the opposite. They were doing exactly that. They were providing direct support for the Contras. They were, in fact, selling weapons to the Hezbollah, and they were using money from the proceeds to help fund the Contras in addition. So that there is a term that's actually used in law. It's a Latin term that refers to commission reports like this. It's unmitigated bullshit is what this Tower report was. This was just absolutely transparent, bogus setup to have a cover-up for the whole thing. But what it did is it sent out a signal to everyone within the governing circles that this was supposed to be the line. This was supposed to be the line that was supposed to be taken. This Lieutenant Colonel Oliver North had gone off on his own. He had utilized the color of his office to recruit a bunch of these former military guys and CIA people, et cetera, and that he had not been reporting to Poindexter. He'd not been reporting any of it to the president. He had no authorization from Poindexter or the president to do this, and nobody else in the National Security Council knew anything about it. That was basically the line that was taken by the Tower Commission. But because of all the major pressure that was going on about this, the revelations that had happened because of Hassenfuss, the revelations of our lawsuit that we had now that Judge King was at full war with us, we were unrestrained in our telling everybody that would listen about what it is that we had found out in the lawsuit. Two committees were set up, a Senate Select Committee on Iran-Contra that was chaired by Senator Inouye of Hawaii. And then there was a House committee that was set up that was chaired by Lee Hamilton of Indiana. Now, what was peculiar was that in the Senate hearing, the Senate Select Committee that was set up, a couple peculiar things happened. Of the 11 people that were assigned, the 11 senators that were assigned to be on the Senate Select Committee, 7 of the 11 had all voted to give $100 million in military aid to the Contras already. And when this set of appointments came down for the committee, we protested and said, look, what's the story here? And they all tried to assure us. They said, oh, we just didn't want to look like a hanging jury. You know, we wanted to be able to have people on the committee so that when they got convinced that this was all going on and they found the people to be guilty, that it would be that much more credible. What really happened was, and then the chairman of the committee, Dan Inouye, basically laid back entirely and allowed the vice chairman, the Republican vice chairman, Warren Rudman, to run the entire hearing and to pick the staff for the committee. And he picked to be the chief investigator for the Senate Select Committee on Iran-Contra, Tom Polgar, who was the CIA station chief that had been appointed by Theodore Shackley to take the the Mexico station that I told you all about, that Joseph Buckholter Smith had told us all about when Polgar came on board. Polgar is the one that had Nasser Haro come and see James Buckholter Smith and take him to meet with all these Nazis in Argentina to let him know that they were all working in a coordinated way with the Contras and everybody else to overthrow their enemies. Okay? And so Tom Polgar ends up being selected to be the chief investigator. So I go to see Warren Rudman. I go over to see Warren Rudman, and I sit down with him in his office, and I start telling him about, look, let me tell you about Polgar, and let me tell you about what these guys are all doing. He literally flew into a rage. I mean, he jumped out of his chair and started screaming and running around the office like, you know, somebody set his pants on fire. And he was just, you people are all trying to just destroy our intelligence community. And I said, this isn't the intelligence community. These are covert operations. There's nothing intelligent about it. You know, I said, this is, and he just went screaming mad and threw me out of his office, actually. It was pretty spectacular. And there's an article that was written about this later by Seymour Hersh. Seymour Hersh at the time was one of the major investigative journalists in the country, working for the New York Times. He wrote a major article for the New York Times magazine eventually on April 29th of 1990, sometime later, because he'd done a full-scale investigation of what had happened. And he stated that he had interviewed Arthur Lyman. Arthur Lyman was the legal counsel for the Democrats in the Senate Select Committee. The Republicans had their own attorney, but Arthur Lyman was the attorney for the Democrats, and he told Cy Hersh that right from the very beginning, he said, look at this, he said, even if we had concluded that the president was directly involved in the diversion of funds to the Contras, an impeachment process had a huge price. In this particular nuclear age, it is something that has to be used very sparingly. We were all very mindful of the fact that there was an opportunity for negotiations with the Soviet Union. But if an impeachment process were started, that opportunity would be lost. What he's saying to him here is that, look, this period where this was all going on was right at the period where the Soviet Union was getting ready to collapse. And therefore, there was this unique opportunity for the United States to step into this vacuum that was going to be created on the world stage when the Soviet Union collapsed. And we didn't want to miss that opportunity. And for that reason, we did not, in fact, want to find any evidence that could support impeachment. Okay? Now, you join that together with the fact that the guy who had written up the charter for the special prosecutor was Edwin Meese, who was a major criminal involved in all the planning of this major operation, these covert operations. He had been the chief of staff for Reagan and Bush all during this period between 1981 to 1984, when a lot of this stuff started. He was the chief of staff, was intimately involved in doing all this stuff. And so that the charter, which he drafted, authorized a special prosecutor to investigate only one narrow question, and that is whether or not President Reagan authorized in writing the diversion of a portion of the funds that were made as a profit from the sale of TOW missiles to the Hezbollah to be diverted to the Contras that would be in violation of the Boland Amendment. That was the only question that the special prosecutor was authorized to investigate. So what they did is he narrowed the investigation to be directed solely to the president even though the special prosecutor statute authorizes them to investigate any high-level official for the violation of any crime. And then the Senate Select Committee picks Tom Polgar to be their chief investigator, puts Warren Rudman in charge of the investigation, and they immediately come to the conclusion that they don't want to impeach the president. And of course, they don't want to impeach anybody else either, because the impeachment would lead to a disruption, or as he put it, a paralysis of the government. Okay? So, and he admitted this. He admitted this to Cy Hirsch. And Cy Hirsch, in this article, this April 29th, 1990 article in the New York Times Magazine, goes on to point out that even with that standard, there was one or more witnesses that could directly testify to their own knowledge that President Reagan had in fact been given the memo telling him in detail about the purchase, the sale of the TOW missiles to the Hezbollah, and the diversion of the money going to the Contras with a specific dollar amount, which was $12 million. Okay, and so this James Radzinski, who was a chief yeoman who was assigned to the White House, he was the administrative officer in charge of System 4, which was the computer system that monitored all the covert operations. And he was the guy, and he went to the committee and told them that he was in charge of passing these memos on to Poindexter from North into the president, and he had done that. And so he was sure that they had seen it, and they just didn't want to call him. They refused to call him repeatedly. And so that from the Senate side, it was perfectly clear that they not only had no intention of finding anything, they actively wanted not to find anything that would require them to bring impeachment action. Okay, and this included all the memos that Poindexter had erased from the computers that they had. And the investigators actually hired Price Waterhouse, who prepared a study showing exactly how to retrieve all of those electronic messages, that they could retrieve all of them. And yet the committee wouldn't authorize them to do that. Okay? And so that on the Senate side, it was perfectly clear that they were taking an immediate dive on the investigation, which shouldn't surprise anyone since they hadn't done anything to begin with. I mean, it was only because of our bringing this case, and then they tried to seal it off so I'd be put in prison if I told anybody about it. And then when Hassenfuss gets shot down, and it goes all over the national media, only then were they dragged kicking and screaming into doing anything about this. And they didn't even do that until after I had gone to Webster through Ross Perot, and Bill Webster had been compelled to start an investigation. And so I was meeting with Danny Coulson and Victor O'Corn and briefing them on what was going on. That was the only time that the special prosecutor came forward, or the attorney general insisted that a special prosecutor be appointed. It was only then that the Congress of the United States did anything about this. So it wasn't as though they couldn't have found out that this was going on. I mean, it was all over the newspapers, and they still hadn't taken any action at all. And with regard to the House committee, again, there were major interviews that were undertaken of these people, and Lee Hamilton, who was the chairman of this committee, Lee Hamilton from Indiana, he constantly talked about how important it was to maintain bipartisanship in this committee. And the guy who headed up the Republicans in this committee was Dick Cheney, at the time a congressman from Wyoming. And what Dick Cheney did in alliance with Henry Hyde and this guy Bill McCollum, who you'll remember I pointed out when I was testifying on October 15th, when Henry Hyde jumped up and started screaming about how he had to shut off all the C-SPAN cameras and this was a violation of the court order and all that. Henry Hyde gets put on the committee to be one of the ones doing the investigation, along with Bill McCollum, who's the other guy that I pointed out. And here's Bill McCollum sitting over here from the 5th District in Florida, who's also a criminal along with you, and here he's on the committee too, okay? And so Dick Cheney led the attack on Lee Hamilton, telling him, his actual quote was, he said, if you try to go down that road toward impeachment, here's what he said. He said, if you try to go down that road, we won't be able to maintain bipartisanship. That was what he said to him. So in other words, if the Democratic majority on the committee tries to actually put forth evidence that supports impeachment, the Republicans won't support them. And so they kept backing away from information. And as it turns out, even when the majority finally ended up writing the opinion, the entire Republican group, Cheney and Hyde and McCollum and the others, dissented and filed a report saying they didn't think there was any kind of wrongdoing that had really been evidenced yet. So none of the efforts at bipartisanship produced anything for the committee. It would have helped if Obama had watched what had happened then. He might have realized that it wasn't going to really pay off. When you're dealing with right-wing people like Cheney and the others, you cannot negotiate with them because all they do is they play their power card. And that's what they did all through this thing. And so the fact is that even though there was tons of evidence that we had, tons of evidence, they just refused to pay any attention to it. And so the House ended up writing a report in which they basically took the position, a lead from the Tower Commission, that it appears that Oliver North is really the guy that was responsible for this. That's what it looks like to them. And since Poindexter now had said that Poindexter had never told the president about this thing, they were saying they were having a difficult time coming to any conclusion that the president knew anything about it. So what you see what happened is the select committees in the Congress, they ended up confining their investigation to the exact same constraints that had been imposed by Ed Meese on the special prosecutor charter. They were only investigating whether or not Reagan himself had in writing authorized the diversion of money from the profits to go to the Contras. And that was all that they were looking at. And they didn't want to hear about anything else. And since they were unable to find any written evidence of that, they said, despite the availability of this yeoman who was testifying directly to the contrary, they figured that they couldn't really get much done. So we started turning our focus over onto the Kerry Committee. Now you remember that right after I came back from filing the case in Miami in May of 1986, I'd gone straight to Tip O'Neill. And I talked with Tip O'Neill about this, and he had sent me over to the Senate side to talk to Claiborne Pell, who was the ranking member of the Senate Judiciary Committee for the Democrats at the time. And I had extracted this promise that if in fact the Democrats were elected in November, that when they came to office in January in the Senate, they would set up a special select committee, which Kerry would head up. Well, they did do that. As the Iran-Contra Select Committee was being put together and under the real de facto supervision of Warren Rudman, there was this other back channel investigation that was going on, the Senate Select Committee on Narcotics and Terrorism is how it got designated, and it was chaired by, a surprise of all things, John Kerry. And so we started bringing all of our evidence to John Kerry. And there was a House committee that started looking into it, in addition to the Iran-Contra committee in the House side. It was the House Select Committee on Narcotics Abuse in the House. It was chaired by Charles Rangel. And when the presiding Methodist bishop, Dale White, the presiding bishop of the entire Methodist Church, they were all working with us because we had this big coalition of many different organizations, church organizations and stuff working with us, that when Bishop Dale White went over to talk directly with Charlie Rangel about this, as the chairman of the committee, he said, he comes back over. We're all sitting in the over in the National Methodist Building, right? And we've got like about 30 or 40 of the major Methodist bishops from all around the country sitting there with us. And Bishop Dale White went over across the street to the Rayburn Building to talk to Charlie Rangel, who was chairing the committee. And he says to Congressman Rangel, he says, Congressman Rangel, what about all these charges that the Christic Institute was making? You know, that Judge King is just saying he's just going to dismiss them. You know, what do you, have you looked into any of those things? And So Bishop White comes back and is reporting to all the other 40 bishops there. He said, and so he said to me, he said, Charlie Rangel said, well, they're all true. All those charges are true. And so Bishop White said to him, well, if they're all true, why aren't you doing anything about this? And he said, well, let me tell you, Bishop. He said, really, there's not enough men over here in the Congress whose closets are personally clean enough to dare to take on these people. That's exactly what he said. And Bishop White is kind of stunned at this and comes kind of staggering across the street back over to the National Methodist Building at 110 Maryland Avenue. Right, you can look right out the window and see the Congress. Comes over there and reports it to them, right, kind of right hot off the griddle. And they're all kind of stunned by this, right? So the House Select Committee on Narcotics wasn't going to investigate it. The House Committee wasn't going to investigate it. The Senate Select Committee wasn't going to investigate it. So we then turned all of our attention to the Kerry Committee, right? And we started bringing all kinds of information to them. We started bringing live witnesses to them. We were bringing pilots that had flown guns out of the Fort Lauderdale Hollywood Airport. We brought them with full copies of their invoices of the military equipment they were carrying, the flight logs that they had, the private code words they used to land down at John Hull's ranch. They had all of that, and then details about the cocaine that they were being directed to fly back. And they sat there under oath, testifying and giving them all the information. We had, for example, we had Wanda Palacio, who testified under oath at great length about how she was at the airport at Barranquilla in the Andean foothills of Colombia, and she sat right there and watched the Southern Air Transport get flown in by Sawyer, the same guy that was piloting the plane that got shot down over Nicaragua on October 5th of 1986. Cooper and Sawyer were the pilot and co-pilot. She said she identified this guy Sawyer as the one who flew a plane into there filled with weapons, and then they loaded it up with cocaine, and she was sitting right there, and she was talking directly to Jorge Ochoa, who was in charge of the whole operation. I mean, direct eyewitness testimony of Ochoa briefing her on what this operation was. And she reports it all to John Kerry and to Jack Blum, their chief investigator. And Jonathan Weiner was there. Jonathan Weiner was the chief legal counsel. So we were just parading witnesses into Kerry's committee, just one after another, giving direct sworn first-person testimony about everything that was going on down there. And as that process was going, I ended up getting a call from Russell Hemingway. Russ Hemingway is the guy who is the chairman of the Committee for an Effective Congress. He's an old friend of John Kennedy's, was in the Navy with John Kennedy, and they were old buddies, and was a major stalwart in town around Washington, D.C. I chaired the Fund for Constitutional Government. He was on the board of that, so I knew him quite well. And he was on the advisory board for our case. So we had a lot of folks that were helping advise us on this. And so Russell calls me as we're going along this process. We're waiting for our appeal to be heard in front of the 11th Circuit Court of Appeals. The other committees are all running around in circles, not really getting anything done. And so we were relying upon the Kerry Committee to help us out. And then all of a sudden, I get a telephone call from Russell Hemingway. And he says, Danny, he says, this is Russ. I said, what, Russ? He said, look, I was just sitting in a meeting with John Kerry. And Don Regal came in from Michigan, Democratic senator from Michigan. And Regal comes in and he says, John, I've got to talk to you right away. And John says, well, that's okay. Russ is fine. You can be here. He says, well, this is very personal. I've got to talk. He said, no, Russ is fine. You can say anything you want. And so Regal says to him, look, I've just gotten out of a meeting with the Democratic Party leadership here in the Senate. And they've asked me to come over to tell you that they've been approached by the leadership of the Republican Party in the Senate here. And the Republicans have offered them a deal that if you will drop this investigation, the Republicans will agree to abandon their demand for the $100 million in military funding for the Contras. and they will support you and the Democrats if you want to support a covert CIA operation to secretly fund the Chamorro campaign down in Nicaragua that is running in a Democratic election against Danny Ortega and Thomas Borge and the Sandinistas. That they're offering an alternative covert operation. That the Democrats, if you will join in this, will agree to withdraw the request for the $100 million straight up from Congress, which has been putting a lot of pressure on you guys out back in your home districts of refusing to support the Contras. You know, you're looking like pro-communists or something down there, supporting that communist government. And so that's the deal that they're offering. And he said, but they said that you have to agree to drop this investigation. And the Democratic leadership wants to make it very clear, John, that this is your call. This is your call. But they've also told me to tell you that if, in fact, you decide to drop this investigation, that the Democratic Party leadership will be very, very, very grateful to you personally in the very near future. And so I said to Russ, what the hell does that mean? And he says, Danny, what that means is that he'll be the nominee for the vice presidency when Al Gore runs for the presidency. And so I was just kind of flabbergasted, right? And the next morning, I get a call from Jonathan Weiner, who is legal counsel for Kerry's staff and his Senate staff. And Jonathan says, Danny, I've got to talk to you. Something very important has come up. And I said, okay, I'll come right on over to the office. He said, no, not in the office. Not in the office. Here's a restaurant. I want you to come and meet me. So I go to the restaurant, and we come in and sit down, and Jonathan Weiner says to me, Danny, something very important has happened. And I said, you're not going to tell me about the Regal meeting from yesterday, are you? And he said, what? He said, wait a second, how do you know about that? And I said, how the hell do I know about anything? I said, why is it we know about everything and you don't know about anything? I said, you guys are the government, we're not. And he said, but look. He said, this is very important. He said, why this means they said that they'd be very, very grateful to him personally if he would go along with this. And I said, well, just what the hell does that mean? He said, that means the vice presidential nomination under Gore when he runs for the presidency. That's what he said to me. And he said, and he looks at me and he said, and you and I will be there, Dan. You and I will be there. I said, fuck you, Jonathan. Fuck you. I said, if I wanted to be in the vice president's office, I would have gone right straight out of Harvard Law School to the vice president's office. I don't have to fart around with all this stuff, I said. These are all quotes. And I said, so I'm not going along with that at all. We didn't spend all this time and energy getting all this information about all these people just to turn around so he could become vice president and we'd be in the staff. And he was just kind of shocked that I wasn't playing that game in Washington, which is what they assume everybody is playing in Washington. That's why you go to Washington, right? And so that I got up and walked out. And within an hour, we get a call in our office from the chief of staff of Kerry's committee, and she is apoplectic. And she's jumping up and down on the phone and saying, look, it's over. Any relationship you had with Kerry is completely over. We don't want you to ever mention his name again. We don't want you to try to associate him with any further investigation. If you're not going to stop your investigation, then don't try to associate Kerry with it. And I said, let me be clear. I wouldn't want to associate myself with John Kerry ever again after what he's done. So she hung up, okay? And so then we'd already seen the draft report for the committee, the Senate Select Committee on Narcotics and Terrorism. We got a draft copy of their report. Had all kinds of the details in there, all the witnesses we had brought them, all the footnotes, all the confirmation, all the appendix with all the documents we had and everything. And all of a sudden they withdrew that. They withdrew the thing and came out with this completely watered down report saying, well, we tried really hard. but we weren't really able to get any conclusive evidence. There's a lot of indications and rumors about some of the pilots that are involved in flying some of the military equipment down. We've confirmed that there was military equipment being flown down, like it was no great revelation. I mean, by that time, everybody in the world knew that. He said, but this thing of being able to find out whether or not the people were really smuggling cocaine and whether or not any of the higher-ups in our administration knew about that, we weren't really able to find anything about that, which was a complete fat lie, total lie. Because we had placed people directly there, and not only that, but we'd gotten a hold of copies of the, that was really a good coup. We got a hold of copies of Oliver North's personal diary, where he had actually put in notes in there about how that they were. I remember one time, for example, we had a thing in there about in his notebooks where he was talking about one of the major Contra leaders, saying that he had in fact wanted to bring in like 3 tons of cocaine into Ilopango all at one time, and that North was saying, no, you can't bring in that much, And then we also had, we presented to them Celerino Castillo. Castillo was the #1 DEA agent in all of Latin America. He was the head guy, and we brought him in and sat him down with John Kerry personally, because I didn't want John Kerry to try to be able to wangle out of it. Set him right down there, and he went into great detail about how he had personally stood right there at Ilopango and watched them come in and land and offload weapons and load on cocaine. He saw the cocaine, he tested the cocaine, it was cocaine, and he saw the money. And he put it right in front of Kerry, just like that. And then he said, not only that, but on January 14th of 1986, he had a direct meeting with Bush, and he told Bush about it. And Bush got up and walked out of the room, wouldn't want to talk to him. He got up and walked away when he was trying to give him the information about all of this, okay? And so we had all of that, but then they turned around and they put out this total whitewash report. And so we were then kind of left standing there. And so we ended up trying to go to all the media, tell all the media about this. And we went to the New York Times and told the New York Times. I told the New York Times reporter about the story, about well, actually how it happened is after Josephus got shot down and all the big blurb went on around and everybody started realizing what was going on, we were invited to go down to the New School for Social Research in New York City. And they had a big closed-door meeting with about maybe 3 times as many people as are here, who were all credentialed journalists. And they all wanted to interview us about what in the world this was all about. And so I was there, and I had up on the stage with me, I had the international desk man for the New York Times. I had Leslie Coburn from CBS. We had one of the people from ABC were there, and they were asking us questions, right? And so I turned to the one of the guys stood up. One of the guys stood up in the audience, and he said, "Wait a second." He said, "If you guys know all about all this kind of stuff, why is it that the New York Times never reported anything about this?" And so I turned to the international desk guy. I said, "Why is that?" And he said, "I don't know why we didn't." And so one of the other reporters said, "Well, would you agree right now with all of your colleagues to send one of your reporters down to talk with the Christic Institute people to get the details about this?" He said, "Yes, I'll do that." And then they said to Leslie Coburn from CBS, they said, "Leslie, do you believe this stuff? Do you believe what they're saying about what's really going on here?" And she said, "Well, we hired Frank Snepp, a former CIA guy, to check all this information out when the Christic Institute people brought this to us. And he checked it all out, and he says it's true. So I believe it is true." In fact, she wrote a book about it. She wrote a book about it called Out of Control. And she did a PBS Frontline story about the whole thing. But the New York Times, the following week, they sent down the fella who is the agricultural reporter for the New York Times because they wanted to be sure to get right down to us fast, and the other people were too busy, they said. So they send this kid down who's the agricultural reporter. And so I say, hey, look, I'll take it. You know, we sit down with him. I remember the great big huge snowstorm, and I brought him into our little cobbler shop, and I sat him down, and I laid the whole thing out to him. I showed him documents, the whole details, and he kept going, wow, this is something. This is really unbelievable. He said, boy, my editors, oh, gee. And he kept saying that over and over again. And so he gets all this stuff, and he leaves, right? So I'm waiting, and 2 or 3 days go by, and another couple, 2 or 3 days go by, and I call him up. And I say, what's the story? What's the story? You got all that information? And he said, look, my editors need some more stuff. They need more stuff. So I said, well, come on back down. So he comes back down. And so I take him, personally, and sit him down with 2 or 3 pilots that have actually been smuggling the stuff, people that I'd given to the Kerry committee that hadn't really done anything with it, right? So I put him right in with the smugglers. They give him all the details. They show him all the documents. He goes, oh, this is great. This will do it. This will do it, he says. And he goes back. And I wait. I heard 2 or 3 days, nothing happens. Another 2 or 3 days, I call him up. I say, what the hell's going on? Why aren't we seeing anything? He said, look, I got to tell you, my editors thought that you weren't going to be able to get that stuff for us. But you did. And he said, they just don't want to do it. They're just not going to report the story. I said, well, why not? He said, I don't know. I'm the agricultural reporter, right? What do I know? He said, but they aren't going to report it. They won't do it. And so that was what happened there with the New York Times. And so I then had explained to him this story. I told him this whole story about the thing with Scott Armstrong, and Scott Armstrong going over and meeting with Peter Rodino and giving him all the information, and Peter Rodino saying, well, I'm not going to allow Congress to investigate anything like that. I told him that story. So the only thing that they report, New York Times comes out with a little short story saying Daniel Sheehan and the Christic Institute are going around telling secondhand stories about aging congressmen. That was what the story was, telling secondhand reports about aging congressmen. They didn't say what they said. They didn't say what we were telling them. That was all they said, just so they could say they wrote something, you know. And that was all. That's all that they reported. And so, and then I remember then the Senate finally calls all their people together. They bring everybody into this great big gigantic room with all the lights in there. They've got Poindexter there. They bring Poindexter in finally. They immunize him, right? They give him complete immunity, and they bring him in, and they say to him, look, we want you to tell us everything that you were doing. So he goes through details about what North and he were doing and all that kind of stuff. And he says, but I never told the president. And North had said, well, I was handing memos up to Poindexter to be signed off by the president, so I assumed the president knew all about this. And so Poindexter says, well, I never told him. I never told him. And so the next day he comes back, and everybody's there bright and shiny at 9 o'clock in the morning with all the lights, the big television lights and everything. And Dan Inouye says to him, well, this morning in the Washington Post, there was a big front page story in which President Reagan states specifically that he was never told by you or by North about these operations. And Poindexter says, see, that's exactly the way we planned it. So he could say he didn't know about it. That was exactly what we did it for. So he could maintain deniability like that. And Dan Inouye looked at him and said, well, I guess that answers the one question we wanted. The only question we were really looking at is whether the president knew about this and had authorized this. So I guess we're done here. He goes like this, and then everybody, like in unison, all fold the papers up on their desk and turn off all the lights. Literally, turned off all the lights and left everybody standing in the dark about what was going on about Iran-Contra. And then they all walk away. And so we were kind of flabbergasted about this whole thing. And we kept trying to get and we were able to get Bill Moyers. Bill Moyers did that great piece that you saw, Our Constitution in Crisis. We got the special video made, Cover Up, that got nominated for an Academy Award. We got Peter Dale Scott and a bunch of other people to write a bunch of books about all this stuff. Bob Perry wrote a bunch of stuff about it. But it was the mainstream media wouldn't do anything about this. And so we were kind of confronted by this, and then the special prosecutor basically ends up coming out with his report, his initial report, and he goes on and on about how what he has concluded is going on here, that there was a major far-reaching conspiracy. He points out expressly that Ed Meese was part of the cover-up, that Ed Meese's demand to have this very narrowly drawn charter was part of the effort to protect the president and all of the people, that he had lost his bearings, that there was such a fundamental conflict of interest that he had as the Attorney General of being both the lawyer for the administration and also the chief law enforcement officer in the country, that he had basically abandoned all of his responsibilities for enforcing the law, and he'd become part of the criminal cabal. And he goes on and on. He says that they were taking aggressive and active steps throughout the entire investigation to try to shut him down. He was complaining. He was filing an interim report with the Court of Appeals that appointed him, and he was saying that they were trying to block me. That when he filed the indictment against Oliver North, the Justice Department, which he was replacing. I mean, the reason he'd been appointed to be a special prosecutor is because the Justice Department couldn't be trusted, right? So when he files the indictment against Oliver North, the Justice Department files an amicus brief supporting North and saying that they didn't believe these were valid charges, they didn't think the evidence was adequate against him, and they actually file a full memo with Judge Gazelle, right? And then North, in complete coordination with the administration, says, "Oh, if you're going to try to prosecute me, I need this, and this, which are all classified documents. I need these classified documents in order to defend myself." And so Gazelle issues an order to the administration saying he'd like to have these declassified, and they refuse. The Reagan-Bush administration refuses, under the Classified Information Procedures Act, to declassify or turn over those documents. And so I realize that this is all going on, so I sit down and I was going to laugh about this one because she remembers this. I drafted up this great big legal memo saying you can't let them get away with this. I mean, you cannot allow a case where the highest level people in the government are involved in criminal conspiracy, requiring the appointment of a special prosecutor. He indicts them, and after they try to fight it off using their power of their Justice Department, now they're refusing to declassify something, and he's going to try to make a motion to have all the charges dismissed against him. You can't, so I draft up all this great big thing, and since Gazelle, you may remember, but Gazelle was the judge who had granted our motion in the Greensboro case to have a special prosecutor appointed. Remember that I ended up going up on appeal and being up in front of Bork on that? Well, it was Gazelle at the district court level that said we were right under the Special Prosecutor Act. So I figure with the kind of cachet I've got with Gazelle, because we've already won one of these things in front of him, I draft up this big legal memo. I contact the Special Prosecutor's Office and get them as one of the two parties in the litigation to consent to my filing it. I get their written consent to filing it, and I get it all typed up and signed, and I go into the courtroom where they're getting ready to have the big gigantic hearing on the motion to dismiss North, right? The charges against North. And so I go in and I say I recognize the guy who was the marshal that was there at the court. He recognized me from the other case. And I said, I've got these motions here, a motion for an amicus brief to be accepted, and I've got the signature of the special prosecutors people. So I'd like to go in and make sure we just serve everybody. And this was at a break, right? A big lunch break. So I go in with like about 10 copies of this thing, and I go into Gazelle's courtroom, and I put a copy of it right in front of everybody. In front of the special prosecutor, in front of all the lawyers for the bad guys. I put it out there, right at their desks like that, right? And I put one up on the bench for Gazelle. And then I leave. And so I come back after lunch, and I'm sitting out in the audience, right? And all of a sudden, there's this big rustle and hubbub going on. All the lawyers are getting up and talking to the judge, hubba. And he says, there's a matter we have to attend to here. And he goes out in the chambers with them. He comes back about 10 minutes later, and he says, something extraordinary has happened here. There's been an amicus brief filed, and only one of the two parties has consented to it, which is all that's necessary, by the way. He said, and the other side hasn't consented to this, and I hadn't heard about this before, and I want to make it clear, he said, he did this, he held it up, he said, I want to make it clear that I haven't read this, nobody's read this, I'm taking the position that it's not appropriate, I won't take any action against the people that filed this, I know who they are, I've had cases with them before, and they're responsible people, but I haven't read this, and we're going to have all of them, hand all of them up to me, and we're going to have them all shredded.
Really?
That's what he said. We're going to have them all shredded, which I thought was at least ironic. And so that's what they did. And then he ends up dismissing the charge against North, the main charges. And the only thing that they ended up being, they ended up convicting Oliver North. You're going to love this one. They ended up convicting Oliver North of a failure to tell the entire truth to Congress about having been given the gift of a security fence by Richard Secord. When he was asked whether he had any history with Richard Secord, or whether he'd ever had any contact with him. As it turns out, they were able to show that he had been given a security fence by Richard Secord to be up around his house. Little side story. The reason he got the security fence is he thought Bill Taylor had killed his dog. That's what he thought. and I said, Bill Taylor doesn't kill dogs, I said, to North. And but anyway, the irony of all of that is that what they convicted him was failing to tell the whole truth about having been given a security fence by Richard Secord, right? And so that all goes up to the Court of Appeals, and the three-judge panel, chaired by a former general counsel for the Central Intelligence Agency, who's one of the three judges now, appointed by Ronald Reagan, and the other one, an assistant United States attorney for the Nixon administration, end up dismissing that charge against North on the grounds that they weren't satisfied that there had been adequate protection given to North because he'd been also given complete immunity for anything in his testimony when he was called to testify. And one of the explicit findings by the special prosecutor is that he says right here, he says, the disrespect for Congress by a powerful president and his appointees was obscured, that's how he put it, was obscured by Congress when they accepted the tendered concept of a runaway conspiracy of subordinate officers and avoided the unpleasant confrontation with the president and his cabinet in the haste of Congress to display and conclude its investigation of this unwelcome issue. Congress intentionally destroyed any effective chance of prosecution by giving immunity to North and Poindexter so that they could exculpate and eliminate any need for the testimony of President Reagan or Vice President Bush. So he expressly concludes that Congress intentionally gave the immunity to Poindexter and to North so that they couldn't be prosecuted and that they could come on and run this dog and pony show of saying that the president didn't know and Bush didn't know, and so the Congress had closed down the investigation. And so he goes on to point out that this conduct on the part of Congress was a complete abrogation of abdication of their responsibility. He said that, and he goes on at great length talking about how the Watergate burglary case made it clear to everybody about how important it was to have oversight authority over the intelligence community in their covert operations. And that was the whole purpose for setting up the Special Prosecutor Act. It was the whole reason for setting up restrictions on the power of the president to engage in covert operations without notifying the Congress of the United States about this. And he goes on. And he said, look, I've got to tell you, he said that Congress's abandonment of their responsibility to enforce the laws and to comply with the laws that were passed by themselves after the Watergate crisis is the core problem here. He said there is clearly a lack of political will, on the part of both political parties to call these people to account for what it is they've done. And he said that, let's be clear about this. This was not, he said, the evidence has clearly shown that the Iran-Contra affair was not a mere aberrational scheme carried out by some cabal of zealots on the National Security Council, as the Congressional Select Committee falsely concluded. He says, instead, it was the direct product of directives issued by President Reagan and George Bush that were executed by the National Security Council staff with the full knowledge and support of the highest officials in the CIA, State Department, and Defense Department. He said, and so he points out that now this is one of those kind of things where everybody could be tempted to jump out of the first-story window and say, what chance is there? How are we ever going to get anything done if even the special prosecutor can't get anything done? But he points out in his final report, he says, fundamentally, what he says is fundamentally, the Iran-Contra affair was the first criminal assault on the post-Watergate rules governing the activity of national security officials. The Reagan administration officials rendered these rules ineffective by creating a private operation supported with privately generated funds that successfully evaded the legislative oversight and control. And Congress was defrauded and its appropriations restrictions were circumvented. And so he goes on to point out that, however, there was this coordination going on between the two political parties in the Congress, coordinating with the White House to conceal what it is that was really going on here and to try to give the false impression. They first tried to give the false impression in the Tower Commission that it was just Oliver North. What he had to do is fall on his sword. That's all he had to do. Just fall on his sword and take the heat for it. They would have convicted him for, jaywalking, and they would have, given him a jail sentence, and he would have come out a hero. But he didn't. He wouldn't do that. Oliver North said, look it, everything that I was doing because I was directed to do it. And John Poindexter directed me to do it, and I had every reason to believe that he was telling the president about this, and I have my direct authority from the president, which was the second grounds for the reversal of his conviction. The former CIA chief counsel and the former assistant United States attorney for Nixon, who were two of the judges on the thing, they actually affirmed his argument that said that I should have been entitled to have Judge Guzell give an instruction to the jury that if they found that I was obeying orders from a superior, that I lacked the criminal intent or the scienter to be guilty of a criminal offense. Now, if you don't recognize that defense, that's the Nuremberg defense. That's the defense that was asserted by all of the high-level Nazi party officials, is you cannot hold me personally responsible because I was only doing what I was ordered to do. Okay? And the two of the three judges on the three-judge panel at the appellate court confirmed that defense and reversed Oliver North's conviction on the grounds that he was not given that instruction to the jury. So it said, but it said that it's perfectly evident here, he said, that there needs to be a strengthening of the special prosecutor statute, that they need to be given power to override decisions made by the executive branch to refuse to declassify information that is necessary to prosecute high-level officials who have violated national security requirements. He said, this has got to be done because it's transparent here that we've been forced to dismiss charges against North and charges against Joseph Fernandez, who was the CIA station chief in Costa Rica, who is the guy that we had also gone after because they were covering for John Hull's ranch down in Costa Rica. But all of these guys that we named ended up being designated by the special prosecutor, basically, of all being directly criminally responsible for all of the conduct that we charged them with the exception of the Lepenka bombing, which the Costa Rican Attorney General's office indicted them for. And they were on the Interpol's most wanted list, including John Hull and the Villaverde brothers and Rene Corvo and the others, the ones that we charged. So that we have now shown that the officials in Costa Rica in charge of prosecuting the murder for the bombing at the Lepenka press conference have all indicted the people that we named. The special prosecutor has indicted the people for the more extensive enterprise that we had designated, and yet Judge King has entered a summary judgment against us, saying that there's not enough evidence to even give rise to a reasonable conclusion on the part of a jury that these things are true. And so we had expected to be able to have a reasonable appeal, but when the special prosecutor ended up returning these indictments, Ross Perot, you recall, who I was in a number of conversations with, was totally upset about all of this, and he decided that he was going to run for the presidency against George Bush Sr. because he had been lied to by George Bush Sr. Turns out that when I was riding on the airplane with him back to Texas, and he said, you know, who do you think we should go see? You know, remember? And he said that, how about George Bush? He's like a Boy Scout. And I told him no. But it turns out he'd gone to see George Bush anyhow, in his capacity, in Perot's capacity as a member of the President's National Security Advisory Committee. So he'd gone to see Bush, and Bush flat out lied to him. Well, it turns out that it was to our benefit, this thing, because when this type of lying on the part of these people, because when Bill Clinton, who was running for had the Democratic nomination, was running, Perot was running as an independent against Bush, and when the election came down, Perot took 19% of the vote. And so Clinton won the presidency with only 43% of the vote. And Bush Sr. got 38% of the vote. And so Bill Clinton comes in to be president, as the Democratic Party had expected he might do, and he brought in Al Gore with him as the vice president, which everybody expected him to do, including John Kerry, remember, who's now waiting. Oh, good, there's Al Gore as vice president now with Clinton, and so Clinton will be president for 8 years. And then when Gore runs for the presidency, I'll be the vice presidential nomination. But it turns out that Gore refused to pick him because Bill Clinton had lied to Gore about his sexual relationship with, what's her name? Monica Lewinsky. It turns out that Bill Clinton had done the old, sit down, Al, let me give you my word. You know, there's nothing to that. No, this was with Lewinsky. He's saying I had no sexual relations with her at all. I'm giving you my personal word, and you can depend on that. And so what happened is Al Gore was going around Washington, D.C. saying, look, I've got this really close relationship with Bill Clinton, and he wouldn't lie to me, and he's absolutely guaranteed me that he's never had any sexual relationship with him, so you can take my word on this. And when it turned out that he was lying, Gore was so furious at him, and you probably don't remember this because you were too young, but the reality is that Al Gore, when he received the nomination for the presidency in 2004, he never once allowed Bill Clinton to appear at a single event for him, or Hillary. And so he went through the entire campaign figuring out that he could win this without Bill Clinton or Hillary's support, to allow them to show up at one single thing. and who he selected for his vice presidential candidate instead of the one that the Democratic Party was insisting that he take, which was John Kerry for his VP in 2000 year 2000 actually. He said that instead of that, who he picked was Joe Lieberman. He picked Joe Lieberman, at that time the Democratic senator from Connecticut, because Joe Lieberman is the first guy who stood up on the floor of the Senate and publicly condemned Bill Clinton for lying to all of his friends. And so Al Gore felt completely warmed the cockles of his heart that he had done that. So he selects him to be the vice presidential candidate instead of John Kerry. So even though John Kerry had completely sold his soul, which probably wasn't the first time, but he completely sold his soul, completely compromised his integrity, was in a position to have been the hero of the day. John Kerry could have stood his ground, could have stood there and said, we've got all of the evidence down to the nit on all of these guys, and these guys are all going to federal prison. And it's going to go right on up the chain because they're all going to squeal like little pigs when they're all put in prison, and they're going to go right up the chain all the way to the president. Okay? And by the way, this BS line that was being given by the senators, both by Lee Hamilton and by Arthur Lyman, both on the Senate side and the House side, as to why they didn't press forward to get an impeachment against these guys. It was because the Soviet Union was getting ready to collapse, and we wanted to have this opportunity to step into the vacuum. Nobody even knew it at that time. I mean, the entire Central Intelligence Agency didn't know it, that the Soviet Union was going to collapse, and it wasn't until 1991. So this whole bull cockamamie story that back in 1987, 1988, 1989, they couldn't really go forward and prosecute these people is just a complete crock. So what we're looking at here is a complete collapse and failure on the part of the American legal system in the face of asserted political power. And so that this is the kind of thing that could cause one pause about going to law school and give one pause about what the potentialities are of invoking the law to attempt to deal with some of these major issues that are going to be confronting you, in the next several years, that I've been talking to you about right at the very beginning, and we're going to be talking about next week. That you could say to yourselves, gee, this doesn't sound like it's worthwhile. So let me tell you a couple more bad stories to really get you dug in. Because I've always said that the happiest time in a trial is when the other side puts on their very best witness. And they get them all on there, and they lie like a dog. And the jury's all sitting there going, whoa, like that. Because then you're always going to say, this is going to be wonderful, when they realize what a total lying scumbag this person is, because they convinced them. They actually convinced them. And now they're going to feel betrayed. And that's why juries convict people, because you lied to them, not because you killed your, the butler or whatever happened. But so the bottom line is that this problem has obtained since the very beginning. I remember that Al Sachs, who I took a constitutional law course from, back at the undergraduate school. He told us a story one time. I happened to do the research on it and find out that he was the clerk for the Supreme Court, Chief Justice of the Supreme Court back in 1945. And he told a story to our class. He said, back in 1941, when the Japanese attacked Pearl Harbor, the president, Roosevelt, at that time, issued an executive order, 1066, in which he divided the United States into 10 separate military districts, and he gave the authority in the executive order of the commanding officer of the Army in that region to issue orders that all private citizens had to abide by in that district. And if anybody violated one of the rules of that the commanding general had issued, that person, an American citizen or others, would be subject to arrest by the military and subject to a court-martial in front of a military court-martial. And if convicted by a majority of the court-martial, they could be imprisoned in a military stockade. Okay? And that was Executive Order 1066. Within a matter of a few days after the executive order had been issued, in Military District Number 1, which is California, the West Coast, because it's such a sensitive area vis-a-vis the Japanese, it turns out that the military was patrolling around in their little green Jeeps, and they spot this family, the Japanese family, having a barbecue. And they go rolling on over into the yard, and there's one of the guys standing there, this guy, Hirobayashi, his name was, third generation American. And they say, he looks like a Japanese to me. And so what they do is they snatch him up. They say, you're in violation of the curfew. It's past 7 o'clock, and you're out here in your yard having a barbecue. And they arrested him. Military, police arrested him. They take him into custody. They throw him in the slammer, and they convict him in front of a military tribunal. And he's totally freaked out, and he contacts the ACLU and says, look, they can't do this to me. I'm an American citizen. You know, that they don't have any authority to do this. And so he appealed. He filed a petition for the issuance of a writ of habeas corpus with the local federal district court, complaining about what had happened to him. Federal district court ends up dismissing the petition. It says that he has to just seek appeal at the military court of appeals. So he goes to the military court of appeals and he files an appeal, and they rule against him. And then it goes by right up to the Supreme Court. It's not a writ of certiorari, it's an actual direct appeal to the Supreme Court. So he goes up to the Supreme Court. This is now, this time it's like 1942, right? And the Supreme Court just sits there looking at it. And that appeal from a direct military conviction to the military court of appeals is sitting in front of the Supreme Court 1942, 1943, 1944, and Hirobayashi is sitting in a military stockade here in California. And the Supreme Court isn't doing anything. And finally, after VJ Day in August of 1945, the day after the VJ Day, the first Monday that they came back into the office, the Chief Justice calls in his clerk. This was in the third person now, that Al wasn't telling us that it was he, but calls in his law clerk and he says, you know, this Hirobayashi case has been sitting around here for a number of years now. And now that the war is over, I think we ought to attend to this. He said, but he's made this argument in his briefs that there's no inherent authority that resides in the executive branch to be able to just issue these executive orders and give authority to the military to arrest American citizens in a military district that they've proclaimed. And so the problem is that he's asserting that without congressional authority to do that, the president doesn't have any such authority to do that. You know, so he said, here are two packets, which I'd like to have you run over. I'd like to have you bring one to the Speaker of the House and the other one to the Majority Leader in the Senate. I'd just like to have you go deliver these for us today. And so Al goes over and he delivers them to the Speaker of the House and to the Majority Leader in the Senate. And the next day, both of the houses of the Congress pass a statute saying in the event that the United States territory is attacked by the Empire of Japan, and the President of the United States will be authorized to issue an executive order saying the following. And they attach, as an attachment, they attach Executive Order 1066 to it. And he said, so the day after they passed that, the Supreme Court sent notice down that they were going to be hearing the Hirobayashi case the following Monday morning. So the following Monday morning, all the lawyers come scrambling in, been waiting now for 4 years, and they come in, and the Chief Justice comes up and he says, before we start here, I'd like to make a note here. He said, that there's an argument that Mr. Hirobayashi has made in the court, is that the executive branch has no inherent authority to be issuing orders like this without there being some congressional authorization to do it. Now that's a very important question, a very important constitutional question. Fortunately, we don't have to address it in this case, because it turns out there is, in fact, a piece of legislation that was just recently passed, and it gives the president the authority to do exactly that. Now, you may, of course, be inclined to make an argument that it's an ex post facto law, but we don't see that anywhere in the briefs here that have been here for 4 years. And so we're going to remand this case back down to the district court down in California and have them review this and to determine if they think this is an ex post facto law that they can release Mr. Hirabayashi. Okay? And the reason that Al Sachs told us that about that case, he says, you need to understand right here at the beginning of your legal career that there are limitations on what it is that the legal system will do. And those considerations are political. That ultimately, the courts in the United States are a political instrument. That the judges are appointed and nominated by the president, which makes it a political nomination. Virtually all of those judges have a political background, and that's why they've been selected, not because of their expertise as lawyers or judges, but they're selected because of their political service to one or another of the two parties. And they're appointed, and they're elevated into the Court of Appeals, into the Supreme Court for political reasons as well. And it was completely understood by the framers of the Constitution that that's exactly how it was to be done. This is completely constitutional. And so you need to, right at the very beginning of your legal career, understand that fact. So that if you think that the law is absolute and that it gives you the right to assert absolute rights in the face of political opposition, you better learn right now that that isn't true. But at the same time, if it's ever going to be true that legal rights are going to be able to be asserted against political power, you're going to have to conduct yourself just as though they're absolute, or else they never will be. And that was the lesson of Al Sachs. And what we've done at the Christic Institute, we have pressed to the limits the abilities of the law. And people were constantly flabbergasted that we were able to achieve any of these things. People never thought that we would be able to, stop construction of private nuclear power plants in the United States. Ever. The billions and billions of dollars invested by the petroleum companies into that particular potential monopoly. Okay? But we trumped them because we had been able to find out that they had not only murdered Karen Silkwood, but that they had done it because she had stumbled onto the fact that they were smuggling bomb-grade plutonium to Israel, in Iran, in South Africa, and Brazil. And so once we had that trump card to play against them, one of their political apparats, who was Judge Tice, brought in from Kansas to hear that trial, he in fact split the difference and gave us the largest judgment in the history of the United States and a ruling that stopped all of the nuclear power plants from being insurable, but did not allow us to get away with blowing the whistle on how they had supplied nuclear weapons materials to Israel. Okay? And so, we realize that this is a mechanism that one has to use in dealing in a political setting with these trials, is that if you're going to be able to get what the law promises, you have to be able to threaten them with more than what it is that you think you're absolutely entitled to. And so in a certain sense, it's a peculiar negotiation that goes on. You've got to present the whole ball of wax to them, and then they're going to give you part of it if you do it well enough. And so the real question that's left for us is what are the lessons to be learned from these various cases that we've all talked about here for the last 9 weeks? And what are the prospects for being able to utilize what you've learned to go into law school, to go into journalism, to go into other forms of art that you would use to try to bring about social justice. And that's what we're going to be talking about next week. Now, I've asked you to take a look at the two cases of Bush v. Gore and Citizens United. Not because I was involved in them, even though my law professors were, but I wasn't. And so that I don't want you to have to go into a lot of detail about it. We're not going to test you on those. I'm just wanting you to take a look at those two cases because you see the degree to which the entire judicial system has drifted toward being political and being taken over by the interests of this 1% to render corporations persons who can spend as much money as they want in political PACs and stuff, and to dominate and control and buy political control in the United States. And on the other hand, to be caught in the embarrassing situation of going back and forth and back and forth and back and forth between the Supreme Court of Florida and the Supreme Court in numerous rulings in which every single time the Supreme Court, the 5-person majority appointed by Reagan and Bush, rules in favor of George Bush Jr. Okay, so that's just an extreme demonstration of the status of things. But we aren't going to be talking in great detail about that. I just want you to have that in mind because what I want to do is I want us to talk in the next two classes about what the lessons are that you have taken from the cases that I've told you. You'll notice that there hasn't been a lot of philosophizing about this. There have been some periodic stuff that's drifted in here and there. But for the most part, it's been a kind of just a rendition of exactly what happened. And so I want you to reflect upon it over the weekend. I want you to reflect upon it. Many of you are writing papers, of course, now about it. But I want you to come to class on Tuesday and Thursday ready to talk about this. Because, you know, up to this point in time, I've basically, for the most part, just talked at you for 90 minutes every time we get together. But I'd like to be able to talk with you in the next two classes about what you think about all of this. And I want to be able to share with you some more philosophical points of view that give you the reason to understand why I am optimistic, even though you wouldn't guess so. Okay? All right. Thank you very much, gang.